John has nothing to say about this.
I agree.
We see a lot of that, and in fact, the things that we're talking about, at least for adversarial parties, is actually more in place to force adversarial parties to share information than there are for parties on the same side to share information. Because judges don't poke their noses into the business that you have on your side, but they poke their nose in when it's between two parties. Sedona has also come out with another publication called the Cooperation Proclamation. Now, it was called the Cooperation Manifesto, but we squelched that pretty quickly. And it's not important in terms of volume. It's important in terms of direction. The Cooperation Proclamation basically says the bar, the attorneys and the judges, should try to separate the zealous advocacy for the facts and the merits of the case from the way they behave when they talk about the mechanics of exchanging documents. And they really start to question whether zealous advocacy in the exchange of documents is helping the process or hurting it. And so they lay out some broad-based guidelines of communicate early, share technical specifications and definitions, involve a translator or an expert if you need to, seek a special magistrate or judiciary focus on this area. And this has been endorsed by judges in almost every jurisdiction in the United States. In fact, I'm involved in 2 cases right now where the judge has come out and said, by the way, I want all parties to know, I personally endorse the Cooperation Proclamation and you will follow it in this case. He doesn't tell us what's going to happen if we don't. He just says you will follow it. You have to use your imagination, like your dad will be home after school. But I think we're going to see more of that. We also see, in practical terms, a lot more 30b6 depositions, where parties are saying, in addition to the document production you're making, we want to take a deposition of somebody at the company IT level, or somebody responsible for document retention and litigation production, to describe how your systems work, what you did to collect documents, and what you did to produce them mechanically. If, any experiences in that area, the 30b6s?
The Discovery Group actually, nationwide, actually helps manage the 30b6 selection and preparation, because we know that that is a commitment to how we manage records in general, as well as obviously the production. That is a major focal point for us in making sure that that's a well-documented process up front, and again, makes it absolutely necessary that we get an opportunity to tell our counsel, our vendors, how things are supposed to go, because we're about to go on the record and represent that not just to our own inner circle, but now to the opposing side.
I think, you know, that's another area where, and probably everybody here is doing this, but that's another area I think where litigation support people are taking on an increased role. One of the things that kind of struck me about this as we were planning for this topic is how much the roles are becoming less distinct between, you know, clients and attorneys and lit support and paralegals. Just last week, in fact, I'm more and more asked to review these kind of documents as they're being drafted by our attorneys. I don't have any legal background. I have very little background in anything of value. But basically, I a lot of times get to take and review some of these documents, so I'll review like a 30b5 or 30b6 draft to say, hey, look, this is what we're looking for. Am I including all the right language? On a case recently, I drafted our e-discovery agreement to the other side, and then of course the attorneys did their thing and made sure that it was something that the courts wouldn't just laugh at. But I think that's a role that I'm increasingly doing at my firm, is really interfacing more with people to make sure that that language we're all talking about is something that everybody's going to understand, and that we're covering all the bases, and that, you know, that our attorneys are getting everything that they need, but being able to say it in a way that everybody who that document's going to go to, or everybody we're trying to communicate with, is going to understand it. And that's why I think, you know, having increased partnerships between folks like me and folks like you guys and the attorneys and our clients is really seminal. We're trying more and more, I think, to put together a team of people basically in every one of these cases that includes those important key business unit people at the client. Because nobody, as Molly already said, nobody knows the documents and the data better than the client does. But we don't know that. So that's a role that I'm seeing, and I'm seeing this diffusion of roles kind of continuing as a trend in our firm, and I think across the nation.
Why does it always come back to me?
I want to go back to the Sedona Conference Cooperation Proclamation. Easy for you to say. I'm going to play the devil's advocate here. And for those of you who haven't had a chance to look at the flash drive, there is a link to this document on the flash drive. But I noticed that there's a listing, the last 2 pages list the different judges and jurisdictions where they basically signed off on this. And it is both encouraging and then a little frightening to me. I saw that there were 2 judges from the Columbus area and then one from the Northern District in Cleveland that has signed off on the proclamation. So the part that I found a little bit disturbing is none of the surrounding states had anybody on that. Now, I don't know if it's a matter of it's just hasn't been updated recently, but I'm kind of curious, has this lost, this was introduced in June 2008, I believe. Do you believe that, and this is for you, Dan, do you believe that the impetus for this has died down, or are there more people signing off on this and we're just not hearing about it?
I think that you're only going to see a drive to have judges actually sign up periodically. It's rather than an open invitation. I think you'll see surges. There was a conference held Wednesday and Thursday in Washington, D.C., the Federal Judiciary, the FJC, Federal Judiciary Conference, held their annual conference. There were 82 judges there. Georgetown and Sedona and the Electronic Discovery Institute together put on an educational platform at Georgetown to bring these judges up to speed. It's important to know that there used to be a clerk at the FJC responsible for judicial education. His name was Ken Withers. Ken left the FJC and went to Sedona, where he's, I don't know his exact title, I think we call him the guy who does everything. He's extremely bright, has a background in law and library science, has been very instrumental in helping Sedona expand its service offerings and its community. So that's going to help periodically bring the judges on board. What else is going to happen is Sedona has created groups, mostly in Working Group 1, because Working Group 1 put together the proclamation, where they're putting together toolkits to actually effect, to put into effect the different principles and give you forms and checklists and ways to communicate and share that information between parties. So I think you're going to see those 2 things come together. So does that answer the question?
Sure.
Do I have another question? Or we add another comment?
Well, I think basically what you started to lead into is how information should be shared, particularly between opposing counsel. And what guidelines are available to help attorneys maximize the effectiveness of communications while still protecting the strategic advantages for their clients?
Well, I think that right now, again, Sedona, I want to use the name only because they've created such a wealth of information that's available for anybody to go in and download. And it's been cited by so many different judges and cited by so many different international courts. There's a lot of information on what the Sedona principles are and how they were used to influence the federal rules. I think looking at the commentary of the Rules Committee to the December 1st, 2006 rule changes is very insightful as to how to interpret those. Looking at Sedona, and then looking at some of the opinions of the recent judges, Judge Facciola, Judge Grimm, Judge Shenlin, and Judge Peck. Those are 4 judges who have really stuck out, really staked out an area in electronic discovery and written some very thoughtful opinions in this area on the recent effects of the Federal Rule of Evidence 502 and its effect on clawback, on the evaluation of search terms and search term technology, on the evaluation of cost sharing, which we don't see a lot anymore, but we can extend that into areas of not reasonably accessible. I'm looking because I see if my colleagues have something to say. I will go back though to communication between parties and miscommunications, because we see that quite often. I gave an example of miscommunication between two counsel over duplication and deduplication. I think the answer to that is to spell it out in documents, often relied upon by technical people to draw, but then backed up by the vocabularies and the glossaries that are available from groups like RFP and EDRL.